Picture this. You are 74 years old. You own your home, your mortgage is paid off, and you have managed your finances responsibly your entire life. Then, a sudden medical emergency strikes. You survive, but you wake up in the hospital completely unable to speak, write, or make decisions. Your daughter drives to the bank to pay your property taxes before the deadline. She walks in, explains the situation, and the teller turns her away. She calls to arrange for your home maintenance, but she can't sign the contracts. The bills continue to pile up, and your family is legally locked out of your life. This happens to American families every single day. The facts I am sharing with you today come directly from the Consumer Financial Protection Bureau, Medicare, and the IRS. There are strict official policies governing exactly who gets to make decisions when you cannot. Navigating those policies is hard enough, but there is an even larger hazard waiting at the end of life. A hidden tax trap enforced by the IRS triggers upon a parent's death and regularly costs heirs hundreds of thousands of dollars in capital gains taxes. The banking and medical systems do not malfunction when a crisis hits. They operate exactly as designed. Families end up paralyzed in these situations because 5 specific, vital documents were never legally filed. Consider Robert, a retired electrician. Over Thanksgiving dinner, he told his 2 children his plans. His daughter would get his house, and his son would get his savings. Everyone agreed. Robert figured that verbal understanding was all they needed. He never wrote it down. 3 months later, Robert suffered a brain bleed. When his daughter tried to pay his taxes, the bank denied her access. When she called to coordinate his benefits, the Social Security Administration informed her she had absolutely no authority to intervene. Without official directives, the family fractured over how to pay the mounting legal and medical bills. The son hired a lawyer and petitioned the court for guardianship. Robert's home sat empty for 11 months while the court proceedings dragged on, resulting in a lien being placed on the property for unpaid taxes. The legal system does not recognize Thanksgiving dinner promises. Without physical documents on file, your wishes evaporate, and courts step in to dictate your legacy. To solve the vulnerability of daily financial control, you need the first document, a durable financial power of attorney. Many seniors assume their spouse or adult child automatically has the right to handle their finances in an emergency. The CFPB is incredibly clear here. They do not. Pay attention to the word durable. A standard power of attorney dies the exact moment you become incapacitated. A durable power of attorney is specifically designed to survive your incapacity, giving your chosen agent the continuous legal authority to pay your mortgage, manage your bank accounts, and even sell your home if needed. The second required document dictates what happens after you are gone, your last will and testament. If you die intestate, meaning without a will, state laws dictate exactly who inherits your home. The state's formula often sends property to distant relatives or creates divided ownership among multiple heirs. Look at this chart to see the cost of dying without a will. On a modest $350,000 home, the probate process can drag on for over a year and drain more than 3% of the estate's value. That is over $10,000 dropped directly into probate court fees, simply to untangle who legally owns the property. By failing to file a durable power of attorney and a will, you forfeit your daily financial autonomy while you are alive, and you lose the right to choose who inherits your largest asset when you pass away. To bypass the probate court entirely, you need document number 3, a transfer on death deed, or if your state doesn't allow one, a revocable living trust. These documents allow your home to pass directly to your designated heir the moment you die. No probate court, no endless waiting, no expensive legal fees. This flowchart illustrates a major CFPB warning. Paying a lawyer to set up a living trust is useless if you skip the final step. You must physically retitle the deed of your home into the name of that trust. If you don't move the actual asset into the legal container, your home still gets stamped for probate. Document number 4 protects your bodily autonomy, the Advanced Healthcare Directive. People frequently assume their financial power of attorney gives their family the right to make life or death medical choices. It does not. You need a specific, separate document to outline your medical wishes and appoint a healthcare proxy. The federal government actually encourages you to get this done. Medicare policies state that the cost of planning your advanced care directives is fully covered during your annual wellness visit with your doctor. Managing a house and managing a heartbeat occur in completely different legal arenas. You must deploy two distinct proactive shields to keep a judge from deciding how you spend your final days. Document number 5 is a maintenance item: property tax exemption applications. Many states offer senior property tax exemptions, but they are not automatic. If you forget to file the renewal forms, you pay full price, slowly bleeding tens of thousands of dollars from your retirement over a decade. Now we arrive at the hidden IRS trap. Many parents think they are doing their children a favor by deeding their home to them as a gift while the parent is still alive. This is one of the most catastrophic financial mistakes a family can make. This split-screen graph breaks down exactly why. Under tax law, when you gift a house while alive, your child inherits your original cost basis. If you bought the home for $60,000 decades ago, and today it is worth $400,000, your child's legal cost basis is only $60,000. That leaves a massive $340,000 gap as a taxable target. When your child eventually sells that gifted home for $400,000, they are hit with a 20% capital gains rate on that entire red section. That is a $68,000 tax bill handed directly to the IRS. But under IRS Section 1014, there is a legal loophole. If you keep the home in your name and your child inherits it after you pass away, the cost basis steps up to the fair market value on the date of your death. The basis becomes $400,000. When they sell it, the capital gains tax is zero. The timeline of exactly when you transfer your property dictates everything. Wait until after you pass away and your child receives total financial security. Transfer it too early and they get a life-altering penalty from the IRS. The government will never send you an alert when you become legally vulnerable. There are no warning lights. You have to take action, and I recommend taking these 3 steps this week. Step 1. Gather and file your 5 documents. If you need help drafting them, call the eldercare locator at 1-800-677-1116. This is a free, federally funded service that connects people over 60 with legal help in their local area to close these gaps. Step 2. Share your documents. A directive locked inside a filing cabinet might as well not exist. Your durable power of attorney needs to be actively reviewed and kept on file with your bank, and your healthcare directive belongs in the hands of your primary doctor before a crisis ever occurs. Step 3. Review everything annually. Laws change, and the people you named as proxies 5 years ago might no longer be the right choice. Pick a date on the calendar, sit down, and verify that your paperwork still matches your exact wishes. Filing these 5 documents takes effort, but it is the ultimate act of love for your family. If you want to stay ahead of the rules governing your money and your home, subscribe to the channel. Protect your legacy on paper so you never leave your family empty-handed when they need you most.